delighted to welcome this panoply of researchers as well as experts to comment on this very important and even disturbing subject, which I hope will underline the importance of the topic being discussed. The discussion today surrounds a book published last year in 2019 called Outrage, the Rise of Religious Offence in Contemporary South Asia. I'm able to hold it up here, published by UCL Press, and is available through open access for anyone who may want to read it from the UCL Press's website. For those of you who are watching, if you would like to ask questions, please ask questions on Facebook and they will be communicated to the speakers. If you would like to ask questions to a specific speaker, please mention the speaker's name. If you would like to ask a general question, please do so. You're very, very welcome. If you are tweeting, please do tag us at @SAsiaLSE and the hashtag is LSE Outrage. The hashtag for UCL Press is @UCL Press if you would like to tag the publishers. I'm going to now introduce the speakers, after which I will say the order in which we will go ahead with this event. But in total, between the editors of the volume and the contributors and the expert commentators, there will be a conversation for roughly about an hour, after which we will have a Q&A session. And as I said, please send the questions via Facebook. It's my very great pleasure now to introduce the editors of the volume. Since there are quite a few of you on screen, please may I request each of you, as I take your name, to nod your head or wave or wink so the audience will know who is who. I'll begin with introducing Paul Rollier, who is Assistant Professor in South Asian Studies at the University of St. Gallen in Switzerland, for those of you who didn't know where St. Gallen is. He's also a social anthropologist and researches on the religion and politics in the everyday in South Asia. Kathinka Froystad is Professor in Modern South Asian Studies at the University of Oslo and is one of the editors of the volume along with Paul Rollier. Kathinka is a social anthropologist as well, and her research focuses mainly on India, and she's interested in studying various aspects of religious complexity. Iselin Frydenlund has contributed the chapter on Myanmar in this volume and is currently professor at the MF Norwegian School of Theology, Religion and Society in Oslo. And I was delighted also to find out that Iselin's research interests extend to Sri Lanka. So I hope that we will be able to involve Iselin in other activities because Sri Lanka is also one of our great interests. I will now, for those of you who had seen Arild's name, Arild Engelsen, Ruud's name, I'm sorry to have to announce that Arild is unable to participate this afternoon due to personal reasons and sends his apologies. Amongst the commentators, I'm delighted to introduce Utsav Bains, who is a human rights lawyer based in New Delhi. Utsav spoke at an event at our center in October 2017, so I'm very happy to welcome him back. That event was shortly after Utsav very successfully managed to have convicted a self-styled godman in India, Gurmeet Ram Rahim Singh, on charges of rape of some of his women followers, which was a very important case in India, and he spoke about it when he came to the center in 2017. So thank you, Utsav, for accepting this invitation. Sara Hossain is a lawyer in the Supreme Court of Bangladesh, an activist, and divides her time between London and Dhaka, and joins us from Dhaka today. Thank you, Sara, for accepting our invitation. And finally, Darr is a barrister and advocate of the Supreme Court of Pakistan and currently lecturer in the School of Law at Coventry University. Over the years, Amber has very generously given her time, expertise, and intellect to several of our events, as also to several events that our students do. I want to say a particular thank you to Utsav and to Sara, who join us from South Asia today, where it is late in the evening. So particular thanks to you. We'll begin, as I said, with inviting Paul and then Kathinka to make some opening remarks, followed by Iselin. Paul.
Thank you very much, Nilanjan, for these kind words of introduction, and thanks to the LSE South Asia Center extend this invitation. It's a real honor for us to know that such distinguished analysts have spent time to read our work. So as one of the three co-editors to this volume, I would like to say a few words about the genesis of the book, its scope, and possibly its limitations as well. This book stems from an interdisciplinary workshop that was held at the University of Oslo 4 years ago, in which we tried to make sense of the apparent rise in the number and intensity of controversies related to religious offense in South Asia, be it accusations of blasphemy or protests or petitions in the name of hurt religious sensibilities. So the resulting book is an attempt to understand why did allegations of religious offense become so pronounced across different political, legal, and religious traditions. Now, the contributors to the volume were specifically asked to ground their reflection in case studies and to frame it in a way which could shed light on the rise of these controversies, again, across South Asia. Now, the fact that we come from different disciplinary backgrounds, so anthropology, study of religions, visual studies, and South Asian languages, means that we did not deploy a single comprehensive framework of analysis. But however, there's a number of shared directions that I would like to sketch out briefly here. First, this research is indebted to historians and social scientists who have worked on legal traditions in South Asia. Now, for us, this body of work provides important clues to understand how outrage and hurt religious sentiments have become such constitutive affects in the political sphere in South Asia. And here we took stock of the fact that paradoxically, somehow, the legal regulation of religious offense often incites the display and mobilization of wounded sentiments. In different ways, both Asad Ali Ahmed's chapter and my own show how legal proceedings of blasphemy cases in Pakistan somehow produce or at least magnify blasphemous subjects and the incriminating evidence. Now, this perspective of the law as a productive field therefore helps us to denaturalize, so to speak, the seemingly spontaneous display of religious outrage. Our second thematic focus has been to contextualize and to historicize this affective response of hurt religious publics. Jürgen Schafflechner's chapter, for instance, shows how subjects may be socialized into developing a specific affect in relationship to alleged acts of blasphemy, an affect that is crafted through a long history of past mobilization and through a specific literary genre in Pakistan. Similarly, in North India, Kathinka Froystad shows that technological transformation can induce a series of micro-affects in its users, which have far-reaching repercussions. So this perspective on affect sheds light on the agentive capacity of outraged publics and their entanglements with materiality, technology, and so on. In so doing, it provides a valuable addition, we think, to the common argument, which is that religious offense controversies are somehow engineered by political and religious entrepreneurs in the hope of gaining electoral benefits. Which leads us to a third perspective shared across a number of chapters, namely the theatrical quality of the politics of religious offense. Arild Ruud, for instance, writes about the ritualistic dimension of these disputes in Bangladesh. To obtain redress, protesters must somehow foreground their hurt and vulnerability according to a well-known repertoire of action. So the performance of outrage somehow becomes part of a political vernacular, if not actually a legitimate modality of public action. What is important to note here, and Iselin Iselin Frydenlund's chapter illustrates this, is that the rhetoric of religious outrage is not contradictory to democracy and to the language of rights. And while these campaigns usually end up reinforcing majoritarian standards and sensibilities, the claim to be heard or the right to offend can be harnessed by marginalized groups as well, as in Mumita Sen's chapter on an Adivasi movement in India. So the politics of religious offense, we suggest, is expanding in the region. The range of potential transgressors is enlarged, partly because the idiom of hurt religious feelings is increasingly shared across political and religious fault lines. This is further compounded by the emergence of skilled entrepreneurs specialized in censoring alleged religious offense, the TLP in Pakistan, for instance, or people like Dinanath Bhatta in India. In this respect, one dimension which we did not develop in detail is the way in which the state apparatus may tap into people's alleged sensitivity to religious offense as a way of curbing political dissent. Now, since writing this book roughly 3 years ago, we witness a growing conflation between accusations of blasphemy and accusations of sedition in the region, whether brought out by elements of the state or externalized to vigilante groups. This conflation illustrates how religious hurt can become a resource for nation building and a means for states to widen their regulatory reach. Now, a further development that certainly deserves sustained attention and on which Kathinka Froystad will say a few words has to do with the way in which the spread of digital mediatization impacts the politics of religious offense. And here, I believe, lies a very important key to understand the transnational nature and pervasiveness of religious offense politics in the region today.
Thank you very much, Paul. For those of you who've joined late, because I'm also watching it live on Facebook beside me, may I introduce once again Kathinka Froystad, who is Professor in Modern South Asian Studies at the University of Oslo and is one of the editors of the volume. Kathinka is a social anthropologist and her research focuses mainly on India, and she's interested in studying various aspects of religious complexity. Kathinka.
Thank you so much. I'll just build on to what my co-editor Paul Rollier just said in introducing some of the analytical perspectives that crystallized as we started working with the book and which we have decided to deepen a little bit. So one of them is obviously the political uses of offense controversies and how they are generated in order to maximize political gains in one way or another. This is a quite obvious perspective that a lot of scholars have drawn attention to before us, but it is still important. So we do not, in this book, we do not argue against anyone in any specific way. We sort of take on board all the perspectives, or most of them anyway, that have come up within this scholarship, and we try to see where can we push it further. So one is obviously the theatrical aspects of political uses of offense controversies. The other one is that we, as Paul Rollier said, draw on this long tradition of scholarship on legal research. How and why did the various censorship sections come into being in each of the South Asian countries, and with what effects? And of course, studying the effects of law has been for a long time a very productive scholarship, and we draw on that and we build on that as well. So this is something that we take on board. And then there is the scholarship of affect, which has also for some time been prominent, increasingly so, I think, within the scholarship of censorship controversies. But where we try to push it further is to go beyond what has been said about the construction or production of a certain range of sensibilities that happened, of course, as the independence movements really started to grow. But there's also a sense in which we can maybe talk about an age of effect in today's life, right? Where everything happens so fast, where political deliberations, which are still going on, but they are somehow overshadowed by these rapid messages, these memes that circulate very rapidly now, that are supposed to make us act in one way or another. And often by combining a certain wickedness with humor, you know, they are made to make us react and respond in whatever way. And so politicians and activists and others utilize that for whatever it's worth. And sometimes they can help in generating or at least magnifying censorship controversies. And so we're talking about also about politics as being increasingly an art of affect engineering. And I think that signals a change in our time, which is not very rapid, but you know, if you look at a longer time perspective, you can definitely see that something has happened over the past decades or so, which I think makes censorship controversies multiply across the entire South Asian region. And then the fourth thing, which is the perspective that has to do with materiality and mediatization, which we think are crucial. So making our point in a materiality perspective, which has long been, well, at least for a few decades, long been prominent in the social sciences, notably my own discipline of social anthropology, then it becomes very interesting to see not just what the message or the offensive message is and its meaning, but also how, I mean, its texture, you know, it's which has a profound effect on the ways in which it can multiply and circulate. And to pay close attention to that is something that some of our contributions do, and which I think has been maybe done too little. Maybe one of the reasons being that it's very uncomfortable to talk about, because once we start dealing with this, it could seem as if the obvious solution would be to curb these kinds of digital expressions, right? Which is what nobody wants, which is a direction that I don't think either governments, I believe, I hope, nor activists or even religious organizations would at present want to go. And if so, what do we do with that? I think that's a discomfort and maybe a discrepancy. That's something we can talk about later between the kind of academic kind of foundational research that we do and the type of research that's being done by, say, human rights organizations or activists who want to curb the or reduce the amount of court cases being gone on for a long time, or perhaps even change the law. So those four perspectives have been very crucial to us, and we have realized their importance as we have been working with this. And of course, one of the things that we also think is important is to really think about the growth of censorship controversies beyond national context, also beyond religious context, because it's very easy to sort of do finger pointing and put the blame on religious bigotry within either camp, or between, or to point the fingers at particular governments or so. But I think we want to insist that it's not quite that easy. There are underlying conditions that affect this region, across religious and national boundaries, and that's what we're trying to do.
Thank you very much, Kathinka. Several important points that between Paul and you, both of you have made. And having read the book, I can't agree with you more, with the exception that at one point you did say that a lot of these memes that start going around, some of them are meant to be funny, but all of us who are now engaged with that region, including all of you, I think will readily agree that we're now at a stage where very little of it is funny anymore, sadly, but there we are. Before I introduce our next speaker, could I just say to Utsav that your camera seems to be switched off, but I just wanted you to know that. Our next speaker is a contributor to the volume, Iselin Frydenlund, who is professor at the MF Norwegian School of Theology, Religion and Society in Oslo, and has contributed the chapter on Myanmar. Iselin research includes Theravada Buddhism, and as such, Iselin is also very well informed about Sri Lanka, which is another area of interest for our center. But this afternoon, Iselin, you will speak on Myanmar. Please speak now.
Hello, good afternoon, everyone. Thanks a lot for this invitation to speak at this great event. So a big hand to the organizers, but also a big thank to the editors of the book, who graciously took on a chapter on Burma, Myanmar, a country that is mostly defined as belonging to Southeast Asia and not very often brought into discussions on countries in the subcontinent as such. But as we all know, Burma was part of British India until 1937, and British Burma adopted the Indian Penal Code in 1861, thus inheriting actually the same religious offence clauses as in the rest of South Asia. So my contribution to the book is one, actually mapping the legal history concerning religious offence in Burma, Myanmar. And the reason for doing that is that very little has been written on this in the case of one, Buddhism, and two, in the specific case of Burma, Myanmar. And the second aim of my contribution is to offer an explanation for why two very particular religious offence cases came into central prominence in 2015. And third, lastly, I mean, very few people who work outside of these countries know that Buddhism has a very strong legalistic tradition. So part of the chapter is also to debunk a few myths about Buddhism, law and society. And I think that's important to bring into the discussion as well. Now, just to sum up very quickly, the main point I make in this chapter is that the two cases from 2015 that I analyze indicate that religious offence legislation in Myanmar is used for Buddhist interest litigation in new and unprecedented ways in Burmese history. And if we just very quickly look back in time, British legal records indicate that such cases were not very frequent at all. The British view Buddhist activism as a threat to the colonial order, thus making charges of sedition more applicable rather than the religious offence legislation. And if we look to the years of military rule in Burma, 1962 to 2011, it's important to notice that military authoritarianism in Burma resulted in changes in the judiciary, remarkably different from developments in India and Sri Lanka. So I would argue that Burma stands out in many ways. The 1947 constitution had established a liberal democratic state, but during military rule, the judiciary lost its independence. By the mid-1970s, the regime had succeeded in eradicating all professional judges in Burma. The judiciary did not respect habeas corpus, the public had little access to courts, and secrecy became the hallmark of the judiciary. And by the 1980s, trials had disappeared altogether from public media. While more research is needed to establish a clear pattern of how religious offence legislation was applied during military rule, my research indicates that cases were few. So defined public enemies by the regime, that is, were rather charged with the Unlawful Association Act, the Emergency Provisions Act, and Penal Code sections on sedition and treason. But as I argue in the chapter in the book, this is to change with political liberalization in 2011. Now, liberalization entailed new political freedoms, but also a very significant rise in Buddhist nationalism, increased Buddhist-Muslim conflict, and legal political activism to protect so-called race and religion. And in the same period, we also witnessed these two cases that I study. They come into central view and great prominence in the public in 2015. And one case concerns the use of a digital image of the Buddha in a bar ad, saying that they will have very cheap margaritas, which is an offense, received as an offense to the Buddhist public. And the other case concerns a lay Buddhist intellectual who in public challenged Buddhist nationalism, arguing that the Buddha was not Burmese. And both cases were promoted by Buddhist nationalist groups. So rather than saying that, well, we have notions of disrespect in the Buddhist traditions, I argue that the rise that we see in several cases, it's not only these two cases I analyze in detail, but several other cases as well. It's more than anything, it's a useful device for the promotion of certain legal political Buddhist interests. And the conjuncture of economic and political liberalization, as well as a new media reality in post-2011 Myanmar, created new spaces for monastic engagements in public life, including legal activism. However, some groups, I mean, not very surprisingly, perhaps benefited more from these new freedoms than others, and the then Thein Sein government's protection of radical Buddhist groups meant that the judiciary, which is not independent from the executive power in Myanmar, was more in tune with Buddhist groups under government protection than monastic groups associated with the opposition. So if we compare just very quickly to Sri Lanka, a strong culture of public law and Buddhist constitutionalism encourage a climate for Buddhist interest litigation. And we have not seen that in Myanmar. Although the state in Myanmar is a de facto Buddhist state, I would argue, but due to the military rule and due to the lack of rule of law, the public law has been weak and Buddhist interest litigation hardly present until 2015. So all this is kind of the result of political liberalization and access to new media structures. And by way of concluding, like elsewhere in South and Southeast Asia, discourses on offense and deviancy are thriving in the new and highly mediatized reality, facilitated by the liberalization of the public sphere. And this is where I think Myanmar compares very well to Indonesia, moving from a military regime to a more democratic state. The social media circulation of offenses against Buddhism fosters the impression of an increasing offense, which needs to be contained through rulings and lawsuits. But as Myanmar stumbles between political liberalization and continued military rule, religious offense constitutes an open legal category contingent upon rapidly shifting political realities. And I think this is what we see now, that when we had a shift in the government in 2016, we then see a clampdown on this Buddhist nationalist group. So now it's them that are charged with offense against Buddhism. I think I'll leave it at that, and I'm looking forward to the discussion and the comments from Paul and all of you. Thank you.
Well, thank you very much, Iselin. Can I begin with saying that at the South Asia Center here, when we started in 2015, we were very clear that we were going to include Myanmar in it. And as a result, we host the Charles Wallace Burma Trust Fellowships here at the center, along with the Charles Wallace Bangladesh Trust and the Charles Wallace Pakistan Trust. When I was reading your article, I was reminded of the very recent controversy between Nepal and India over the birthplace of the Lord Buddha, because this whole thing of, is the Buddha, is he Burmese or is he not? And it has a very interesting resonance, especially when one travels extensively I have traveled in Sri Lanka. I haven't been to Myanmar, where there are very established protocols of how to behave in front of the Buddha statue, and to have your if you're wearing shorts, then you have to have your legs covered or not stand with your back towards the Buddha, and so on and so forth. But yes, we're all looking forward now to the commentary. And before I introduce Paul Fuller, who will comment on Iselin's article in particular, but also more generally as he would wish to, could I just say that one of the questions that was raised by some of the people who are currently watching, so this is for the benefit of all viewers, is that when we decided on the commentators, we purposely chose commentators who had academic/legal background on this subject and were aware of this, because it is also such, as has been expressed by the three speakers just now, there is also such an important legal context in which all this functions. There is not just a legality to it, but law, and it's not just the inheritance of colonial laws, but it is also law acts as the vehicle. It's almost like the engine through which people realize these senses of outrage in society by bringing to court and all the various cases that have been mentioned. So we did think, I personally did think, that it would be very, very useful to hear the views of academics, lawyers, legal experts, and legal practitioners. And this is the reason why we have this very privileged group of commentators, of whom the first is, I'm delighted to introduce Dr. Paul Fuller, who lectures in Buddhist studies at Bath Spa University and specializes in Buddhist philosophy and engaged Buddhism. We are delighted to welcome you, Paul, and for accepting this invitation, and we look forward to your comments. It is in no way to suggest that you can limit your comments only to what Iselin has said. You're free to comment more widely as well. Thank you. Please start.
Thank you ever so much, Nilanjan. It's very good to be with you all. It's very nice to meet everyone who's there. Yeah, so I've been given the task of commenting upon Iselin's wonderful chapter. So let me begin with some general comments. Many would be surprised that Buddhism has a concept of blasphemy. So the Buddha we are most familiar with is located in the ancient Buddhist scriptures. He is a figure of kindness, compassion, and very definitely a figure of tolerance. Buddhists who are outraged at the misuse of images of him must have an incorrect understanding of his teachings, or of the teachings of Buddhism. In the Pali Canon, for example, the Buddha explicitly stated that one should not be offended by those who disparage him. So the central idea is one of non-attachment. Blasphemy and intolerance simply do not fit into the conceptual framework of Buddhism. Let me move on to my next point. So Iselin Frydenlund has written an excellent chapter, The Rise of Religious Offence in Transitional Myanmar, which addresses the outrage of Buddhists and the offence they feel at the lack of reverence shown to its sacred material culture. I've only got time to pick on a few points of Iselin's chapter, which is really rich in detail. She describes the episode in 2015, which she just alluded to, where 3 individuals, a New Zealander and 2 Myanmar nationals, made an image of the Buddha to promote their Yangon bar. It depicted the Buddha in mock DJ mode, somewhat 1990s Manchester rave scene, which Iselin describes simply as the Buddha with headphones. The real import is that the Buddha is depicted not as an object of veneration and protection, but as some sort of inebriated trance-like tranced-out icon. This caused offence, particularly to a nationalist group of monks known as Madata, the Organisation for the Protection of Race and Religion. Notorious for their efforts to protect and defend Buddhism, these monks pressed the charges against the 3 individuals, and they were subsequently given 2.5-year prison sentences with hard labour. And in the context of Myanmar, one can only imagine what that actually means. Let me move on to my next point, that to do with blasphemy in Pali Canon, before returning to Iselin's chapter in more detail. So I think there are two important questions: why the offence and why the reaction? In my own work on blasphemy in Buddhism, which Iselin kindly refers to, I've suggested that the notion of blasphemy can be found in the early Buddhist scriptures. And there are conceptual terms and categories that point to such a notion. I agree with Iselin in her chapter that the monks from the Mabhata group, the Organisation for the Protection of Race and Religion, were very unlikely to be familiar with these textual passages. However, I would still hold that the textual episodes anticipate some of their sentiments. Blasphemy, outrage, intolerance, and offence are part of the conceptual vocabulary of Buddhism. So let me turn to my next point, blasphemy in colonial law. Iselin's chapter argues that the modern formation of blasphemy in Burmese Buddhism is based in colonial history. That makes up the substantial contribution of her excellent analysis. Modern Burmese Buddhists' attitude related to blasphemy originate in the colonial legacy and British control of Burmese legal affairs. There are notable articles in British colonial laws which outlaw offending religious sentiments. They were originally intended to promote communal harmony. These form the basis of the charges against the three individuals to which I've just referred to the Dijane Buddha image. Iselin argues that colonial laws were used and exploited by nationalist monks because these laws serve the purposes of nationalist and protectionist Buddhism. Iselin, in her other work, has written a lot about protectionist Buddhism. The idea is that in modern Burmese Buddhist communities and organizations, one of their main aims is to protect and defend Buddhism against a perceived threat. And the threat perceived is often from the Muslim communities. So there's a new phenomenon which Iselin has written a lot about to do with protectionist Buddhism. So I think Iselin's analysis has really great value. I don't really fundamentally disagree with it, but we are still left with some questions as to why the offence and why the reactions. And answers to these questions can be addressed from a wider Buddhist studies perspective. As I've said, Iselin would argue that patterns of nationalistic behaviour can be found in the historical and colonial legacy of Buddhism in Myanmar. I would suggest that there are also mechanisms within Buddhism, textual in terms of a vocabulary, and conceptual to do with the sacredness and power of images of the Buddha, which describes a wider Pan-Asian Buddhist sentiment comparable to blasphemy. So in many ways, the situation in modern Myanmar is a perfect storm of two different things: a colonial legacy in which colonial laws were brought into the service of nationalistic monks, the idea that Buddhism needs to be protected, its sacred material culture is being misused and abused, And the second part of this storm is the modern commercialization of Buddhism in the social media age. Individuals arrested and deported around Buddhist Asia for displaying tattoos of the Buddha. James Mark Shield's excellent article on the Victoria's Secret Buddha bikini. Won't go into details about this. This is where the Buddha is displayed on a rather explicit and scantily clad bikini. The Knowing Buddha organization in Thailand, a lay organization which campaigns against the inappropriate misuse of images of the Buddha. In many ways, it is precisely those individuals who find in Buddhism a liberal freedom of expression who are offending conservative attitudes around Myanmar. So to conclude, those who find in the idea of blasphemy in Buddhism surprising are basing their idea upon the assumption on those aspects of ancient Buddhism which promotes an intolerant Buddha removed from politics and culture. I would suggest that this is a romanticized Buddha and the tolerant Buddhism of popular culture. It is a Buddha removed from his religious and cultural context. The Buddha, or the Buddhism of Buddhism, blasphemy and outrage, is one in which his image is sacred and has power. It is a Buddhism of politics and self-interest, of culture, a localized form of Buddhism, far removed from the modern conception of Buddhism with a universal type message. As Iselin's chapter brilliantly suggests, local agendas, recent history, and above all, colonial legacies need to be appreciated to understand the rhetoric of Buddhism and blasphemy. Thank you.
Thank you, Paul. There was a bit towards the end that at least I couldn't hear, but Iselin, could you get all of what Paul said? There were bits because of the connectivity that we couldn't get, but perhaps, Paul, we can come back to it later on. Before I invite Amber to speak, I just wanted to say that, we did this very interesting event a few weeks ago. This was a book on everyday forms of justice in Myanmar by Helena Maria Q in Copenhagen. And there was a very interesting discussion about local forms of justice that are at practice, because people naturally tend to be so suspicious of the formal systems of justice in Myanmar. But it was a very fascinating discussion. Could I also suggest, and this was something I was going to mention in my introductory remarks, for all of you, not just the commentators, but also the editors, to think a bit, and we should have a brief chat about it once all the commentators have spoken, on the various kinds of terms that we come across that get translated and captured in English words like blasphemy and offense and etc., because there are a lot of non-English languages at work over here. This is not, I'm not trying to make a case for things getting lost in translation. I think we're all agreed on that, but having done my own research in Persian language and then having had to express it in the English language, I have often been confronted by this very interesting paradox. And there is a discussion about it briefly in the introduction, but it will be very useful to hear just from all of you, just on your individual case studies. You don't have to speak for those who are not present over here. But may I invite Amber? Also, I've just had a message from Utsav to say that he's having some connectivity problems, so he's working on it, and he's going to be back, to those of you who can't see him on your screen. Amber Darr is a barrister and advocate in the Supreme Court of Pakistan, and is currently lecturer in the School of Law at Coventry University. Over the years, Amber has participated in several events at the center and has given very freely and very generously of her time, her expertise, and her intellect to our events. So Amber, thank you very much, and welcome once again.
Thank you, Nilanjan. It is a real pleasure to share my thoughts on this very important volume that traces the many different manifestations of blasphemy across South Asia. I will be responding to 3 chapters that specifically address the incidents of blasphemy in Pakistan. These are chapter 2 by Paul Rollier, which deals with the offense of blasphemy more generally and argues that concerns about blasphemy do not stem only from religious beliefs, but also from the quest for political relevance and for control over public space. There's chapter 7 by Asad Ali Ahmed, which recounts the court proceedings in the Yusuf Ali case. This was a man who claimed prophethood, and discusses how the Pakistani legal system employs language to obscure rather than uncover the truth. I'll also be talking about chapter 8, which focuses on the Asia Bibi and Amir Chima cases, to argue that when literature extols certain behaviors and emotions, such as the uncontrollable urge to kill an alleged blasphemer, it actually ends up perpetuating such behaviors and emotions and encouraging others to emulate it. So an important thread that runs through these chapters is that the offense of blasphemy is in fact a colonial construct introduced by the British as much for ease of governance as for maintaining the sanctity of different religious groups. What I find interesting is that despite the fact that Pakistan shares this colonial legacy with other South Asian countries, its increasingly vehement response to blasphemy is almost entirely its own. For me, especially in my capacity as a lawyer, what is important is to examine the institutional factors that shape Pakistan's response to this issue. And I suggest that in the Pakistani context, whilst blasphemy, both the offense and the response to it, may have started off as simply one aspect of a wider project of Islamization, it has grown in magnitude as other institutions of law enforcement, justice, and governance have become weaker. So what do I mean by this project of Islamization? Simply put, it is the project to establish the supremacy of Islam and thereby to provide security to Muslims. The genesis of this project does not lie in the Zia era, as is commonly believed, although that period is certainly significant. In fact, it may be traced as far back as to the period immediately prior to the 1857 War of Independence. As the political power of Muslims declined and they came under increasing pressure from the British, their need to protect their religion and thereby their group identity as Muslims became more heightened. In fact, the well-rehearsed slogan, Islam khatre mein hai, often invoked in Pakistan to justify reactions to insults against Islam, was coined in that period. So when Pakistan when Pakistan is created as a country in which, to paraphrase Jinnah, Muslims would be free to practice their religion, it also inherits this insecure identity. And now, even more so than in the British era, being Muslim confers a sort of a higher order citizenship, as it were, and safeguarding the religion becomes a proxy for patriotism. The slogan Islam khatre mein hai, therefore expresses a temporal fear for one's existence rather than simply a spiritual fear, and becomes the rallying cry whenever there's a real or imaginary threat to the country, either from internal or external forces. So when Paul Rollier in chapter 3 quotes the Pakistani Christian Aftab, who is a relative of a blasphemy accused, as saying, "We are all blasphemers," he's actually hinting at, to me, he's hinting at the suspicion with which Pakistani Christians are viewed in their relationship with Islam, and therefore by extension in their relationship with the country. In time, it appears that they too have come to view themselves through this lens, and they somehow believe that in being Christian, they're not entitled to the rights afforded to their Muslim counterparts. This insecurity, what I refer to as insecurity, has also acted as a driver for the Islamization project from the earliest days of Pakistan's creation. So even before the Zia era, Muslim scholars such as Professor Fazlur Rahman, later at the University of Chicago, were of the view that the Pakistani constitution was not Islamic enough because we were only, it only stated that laws that were repugnant to the injunctions of Islam would not be enacted, but it didn't use Islam as a positive force behind lawmaking. In the years that followed, state institutions have led the way in trying to overcome this insufficiency, as it were. You have, in 1974, Bhutto, the great secular leader, amends the Pakistani constitution to declare Ahmadis to be non-Muslims. In 1984, Zia held the dubious referendum in which he says, "Do you support my proposal for amending laws to bring them in line with Islam?" And if you answer yes to that, then of course you support him. And we basically gave him, conferred on him the legitimacy to amend the constitution, make Islam more fully a part of the constitution, and to establish the federal Shariat court system. In 1993, the Supreme Court issues a judgment in the Zahiruddin case, which later came to be known as the Ahmadiyya judgment. And they confirmed the offense. They confirmed that if an Ahmadi calls himself a Muslim, it is an offense under the Pakistan Penal Code. Interestingly, what has happened is that people themselves started invoking Islam to hold the institutions of state to account. So a very interesting example of this is the mass movement led by Maulana Fazlullah in what is now Khyber Pakhtunkhwa. This was the TNSM, the Tehreek-e-Nifaz-e-Shariat movement. And interestingly, this was largely against the confused law enforcement mechanisms in place in the region. And such was the power of this movement that successive governments, there was Benazir Bhutto in 1994, Nawaz Sharif in 1999, Yusuf Raza Gilani in 2009, were forced to issue some version of the Nizam-e-Adl regulations. But again, for political reasons, to reassert their writ in the region than to specifically promote Islam. More recently, in the Supreme Court's judgment in the Asya Bibi case, which Jürgen Schafflechner talks about at length in Chapter 8, the judges of the Supreme Court refer to Ilmdin as a Ghazi and a great lover of the Prophet, arguably because to say anything else would not be palatable to the masses. What is ironic is that in doing so, they're in fact playing the same role that Jürgen Schafflechner attributes to the literature, and in extolling Ilmdin while at the same time holding Mumtaz Qadri liable for breach of rule of law, they're at best sending very mixed messages to the public. So when Asad Ali Ahmed in Chapter 7 very rightly notes that the language of the courts appears to be designed to confuse rather than illuminate, he is also hinting at the fact that judges of the Lahore High Court, in which the Yusuf Ali case was tried, share the attitudes of their colleagues in the Supreme Court, which in turn means that in any case of alleged blasphemy, no matter how tenuous it may be on facts, it is Islam and not the truth that will always be saved. So I would like to end here by noting that the different aspects of blasphemy touched upon in these 3 chapters, in fact, reflect an inversion of the legal category of Muslim created in the British era. So it's no longer the state that decides what Islam is or uses the offense of blasphemy as a shield to protect Muslim beliefs, which is, I imagine, which is the reason it started back in the colonial period. But in fact, it's the people who claim Islam for themselves, and they wield blasphemy as a sword to assert their claim, leaving state institutions little choice but to align themselves with this claimed version of Islam in order to maintain their legitimacy.
Thank you very much, Amber. Could I just say before I invite Sara that for those of you who are watching on Facebook, if you would like to ask questions, please feel free to send them on Facebook and we will post them to the speakers. But may I now invite Sara Hossain, who's a lawyer in the Supreme Court of Bangladesh, is an activist and divides her time between London and Dhaka and joins us today from Dhaka. Sara.
Thank you so much, Nilanjan. Well, I'm afraid I have to start by saying I can't really recognize the description of Mr. Bhutto as a great secular leader. Certainly from Bangladesh, we see him as someone who's complicit in the genocide and highly communal politics. So I'm sorry, I have to just put that on the record. And the other thing, I think I'm going to speak from a different perspective. I think definitely not an academic perspective. And I'm going to try and sort of relate what I read in the bits of the book that I did read, the introduction in the Bangladesh chapter, to I think some of our contemporary realities, and also I think to the context of the fact we live in not only post-colonial nations, but those with their own constitutions and protections around freedom of expression and around equality, as well as freedom of religion. And I mean, one sentence really struck me when I was sort of preparing, thinking about what to say here, and I think that's probably in the introduction. There's a sentence, I think, about how making any public critique of these issues around religious offense is now perhaps too dangerous to voice. And I think I can see all my previous speakers have been very circumspect and used lots of academic terminology. So the risk of being dangerous, I think, is lessened, and probably a very sensible tactic. In terms of what I read and what I found the book, and particularly the introduction, very valuable for, I think is there a sort of reiteration of the history of the kind of law and politics around the definition of the offenses around hurt to religious sentiment and the related offenses, and the connection between those and blasphemy, and drawing on some of the distinctions as well was really, I think, useful to see that set out clearly. I would have liked to see more, I think, tracing how the successful efforts that have beat back the attempts to bring in definitions into international law of defamation of religion were in fact defeated, at least have been defeated for the moment. But it would have been very interesting to see to see more, I think, analysis around how those similar kinds of efforts have been used in national contexts as well, you know, trying to shift, to sort of regress back even further, if you like, from looking at how individual sentiments to hurt to how the religion itself is defamed. So how to bring blasphemy back into these laws, the colonial laws, which don't have blasphemy in the South Asian context, but do have religious sentiment, and the efforts in the post-colonial context by fundamentalist groups to take us into the era of blasphemy, into the arena of blasphemy. You know, what the Pakistanis have achieved in their legislation and what the rest of us fortunately don't have yet, at least in India and Bangladesh. So whatever I'd like to see more, and maybe there could be a volume 2 that would be interesting. I think the other things I found very valuable was, of course, tracing how the context, the changed context of religious offense in an offline world is pretty much transformed in an online world. And you know, how the transition of this speech, even speech that is made in fact offline, as soon as it's put online, has a completely different dimension and a completely different trajectory. And particularly, I think the highlighting of social media and how social media has been the avenue for that. And again, it would have been interesting, I think, to look more at what is the legal framework that, I mean, I understand that as a lawyer, it would have been very interesting for me to read more about the intersections with the legal framework and the regulatory framework and the gaps and the difficulties of trying to respond to this kind of fast-moving, accelerated kind of sentiment hurting, so-called, and the way in which that's also instrumentalized. So I think some of the gaps also I saw in the book, and which made me think about the gaps. So I think it was very helpful and provocative in that sense. I sort of kept thinking that the historical part I'm finding really interesting, but what I'm not understanding is why is there not more of a discussion of the contemporary, and why is there not more of a discussion around the kind of democracy deficit within which these cases are taking place. And the fact that in many of our contexts, we are living under authoritarian and repressive governments. We're living in a world of mass surveillance. We're living in a situation where we have constitutional standards on freedom of expression, but we don't have robust systems for enforcing those standards. And when we do approach courts, we often approach them in a very defensive fashion to just secure basic liberties and freedom and not to be incarcerated for alleged hurt to religious sentiment, and not to really proactively secure our rights. So for example, a person who's not a religious believer doesn't have much chance of having the fact they're being offended by constant religious speech. They have no chance really of getting any of asserting that in a proactive way. And one other issue I think that also kept hitting me quite a lot when I was reading the book is there's quite a lot of discussion about what Muslims say and what Muslims feel and so on. I think there's a bit of a danger in doing that, and that Muslims, like any community, are not a monolith. And there are many Muslims who do not feel religiously offended by a lot of the speech. And I think I particularly found this in the discussion of the Rushdie affair, when the authors speak about how Muslims stood and protested. Very good and close friends and colleagues of mine were Muslims, Hindus, Sikhs, and people of no faith who stood against those protesters and stood for the right to defend Rushdie's right, and more importantly, their own and all of our own rights to read. So I think we do have to remember that, and remember that exactly those debates and those contestations are going on in all of our countries, that there are progressive forces also claiming to be part of religious traditions, also claiming to be part of communities, and standing not only against these extremist readings, but also this unholy alliance between extremists and these authoritarian states which lack democratic legitimacy and which need to kind of draw on these kinds of other forces to prop themselves up. So just to end, I think the case that I read, the Bangladesh chapter, deals with a particular case of a former minister of the current ruling party who was accused of hurting religious sentiment because of some comments he made about the Hajj. And he also incidentally, and this is mentioned in a footnote, also made comments about one of the prime minister's son, which also considered to be defamatory. And the paper discusses, of course, the religious offense and not the other situation, but and I'm not going to go into that for the very reason that I think it's too dangerous to speak about that on a webinar or on Facebook. Because the reality is now in Bangladesh, although we have many cases of hurt to religious sentiment and very problematic use of those and people being incarcerated for months on end, we have a vast majority of cases which are about something even more bizarre, which is hurt to the image of the nation. And we also see cases now, I've seen police, FIRs, where hurt to religious sentiment is elided with hurt to the image of the nation. I mean, it's just completely thoughtless, mindless kind of FIR that some police officers written, but they're just happily banging all these things together, and one has now become seamlessly intertwined with the other. And so I think the difference we see is how are colonial laws being re-embedded into post-colonial legislation, post-constitutional legislation, and made worse. So the hurt religious sentiment offense you speak about, the section 295A of the penal code, which we at least share in India and Bangladesh, that had protections. If you wanted to arrest somebody under that, you had to get an arrest warrant. If you wanted to pursue the case against them, you had to get a sanction from the Home Ministry, and the sentence was only 2 years. Now, under our new offenses, any constable can go to anyone's home at any hour of day or night and pick them up, and they do that. No sanction is needed from the Home Ministry, and people routinely spend month on month in prison. So I think what the book has done is, put all that out there, shown us what's happening with religious offenses. And I think it's a great call to arms for people to now look at what is happening with the pattern of abuse of the religious offense provisions in the context of sedition and in the context of this bizarre thing of hurting the image of the nation, and also actually in the context of criminal defamation laws, which we still have, and how these are all being used in the very lived reality that we all have, where our states routinely indulge in and encourage the abuse of this kind of legislation by party political followers and others to persecute and harass political dissenters, and often make these unholy alliances with extremist groups in order to consolidate their political power and shut down any kind of critique. So I think it's very interesting that the book has done that, and I think it definitely repays consideration by all those who are involved in activism on these issues and work on these issues in all our countries.
Sara, thank you very much. And thank you also, and especially for raising this point of how colonial laws are getting embedded or re-embedded in post-constitutional, post-colonial settings, and etc. Because one of the things and one of the things that concerns all of us is also how so much of this, or some of it, or how much of it may actually be opportunistic scenarios for certain groups to bring forth certain sorts of positions. But thank you very much for raising the whole question of the framework of colonial laws. Unfortunately, I think we seem to have lost Utsav, because I've been communicating with him on email, which is why I keep looking in this direction. But I think he's having serious internet connectivity problems, so he's stopped responding on email as well. What we'll do then is that we'll just move on to our discussion. There are some questions I can see on Facebook. But before that, could I ask if the editors of the volume, or if Iselin is a contributor, would you like to respond to any of the things that Paul and Sara and Amber have said?
If I could take the opportunity to just thank them all for their very valuable comments. I think that would be it. I really appreciate that you have read it and you are engaging with it and you are raising some critical points and pointing out some of the gaps. This is precisely the kind of conversation that we wanted to have and that we want to have more of. So I think this is wonderful, but I don't think I want to sort of enter any specifics at this point of time.
Paul, did you want to say anything?
Nothing specifically. Maybe it will come up later, but I think there weren't any specific questions. But yeah, maybe let's keep it for later. Let's.
Okay, Iselin, did you want to say something too?
Well, just to thank the commentators for great comments and reflection, and for my part, particularly to Paul for reading his my chapter so thoughtfully. And just to add or to agree with you on the point of globalization and the commodification and commercialization of Buddhist objects, I think this is a point that we can again discuss all amongst us which is very important in various Buddhist contexts, not only in Myanmar, but in Sri Lanka and in Thailand. And you also see that kind of activities among Buddhists in Europe, that they organize campaigns against the doormats with the Buddha on it, and trying to explain why, from a Buddhist point of view, this might seem as disrespectful. But this Buddhism being used in a very sort of hyper commercialized way, and something that you adorn your bathroom with, which to Asian Buddhist sensibilities is deeply disrespectful. There is something here about the globalization and the economy, the global economy in all this, that it would be interesting to discuss across cases.
Thank you very much, Iselin. For those of you who do follow the language, there is a very, very moving and a very stark poem on what Iselin has just mentioned, which is the use of Buddha as an idol, as an imagery by different people in different parts of the world, that is very directly offensive to those who follow the religion. And it's a poem by Harivansh Rai Bachchan, and is recited by his son, the actor Amitabh Bachchan, in Hindi. And there's one line in it where it actually says that, you know, his head was bald, but we decided to give him curly hair. So I'm going to bring the commentators in to have a conversation, both about what is being asked, but also in the context of what has been said by one another. But we do have questions raining in. So could I just introduce a few questions? One is to all of you, which is, what about offensive statements by religious people that those who are non-religious have to put up with? This is to all of you. There is another question that is directed particularly to Amber and to Sara, but others, especially Paul Rollier, you, since your article deals with Pakistan, are also welcome to comment on. I'm going to read it out. It's slightly long, but it's an important question. And so if all of you could keep your answers brief. So this is to Amber, to Sara, and to Paul Rollier. Blasphemy is used as a tool beyond affect. It is deployed for hegemonic control and erasing minorities or forced conversion, but most of all, it is used the most in intra-Muslim attacks. So what is Islam being threatened with if it is all Muslims who are claiming injury? What is the value of the analysis of the colonial aspect of laws when it is now completely co-opted and used for the benefit of Muslims by Muslims against Muslims? Okay, this was directed to the three of you. There are more questions, I'm afraid, that are coming, but I will, for the moment, limit it to these two. So if we could go to the first question, which was, what about offensive statements by religious people towards those who are those who identify as non-religious themselves within the South Asian region? And Kathinka, could we start with you, please?
Yes, certainly. I'm afraid that is not really a question that we have tackled in this book, because we have been dealing with questions of offense on religious grounds, hurt religious sentiments, because that's the kind of offenses that are so deeply enshrined in law in the South Asian countries. Now, of course, people who define themselves as atheists or non-believers, they do not have the same legal protection, in spite of the fact that at least India, which I know best, is a country which professes total religious freedom. But then, of course, what is the religious freedom for rationalists? We've seen some disturbing incidents in the latest years, where it's not just a question of what one can have to put up with, but also whether one can actually speak out and sort of claim, you know, a rationalist ground point and speak against persons of religion. Whereas, of course, it is those persons who have been attacked by the rationalists who have tried to use the law to try to silence them. So that has been a problem, but unfortunately that is not something that we have dealt with in this book. So this will have to be one suggested that we had to have a volume 2 on something, so this will have to be a volume 3 then.
Sorry, anyone else who wants to take on the point about comments made by, offensive comments made by religious people towards non-religious people?
Yeah, I mean, we don't see any action on that. And there are multiple offensive comments, and they're made every day in waz mehfils, you know, in public events, public religious gatherings, extremely misogynist remarks about women, extremely homophobic remarks, extremely communal sectarian remarks about people of other religions, and indeed also extremely offensive remarks about other Muslims, for example, against Ahmadis in particular. They're extremely beyond offensive. I mean, there are remarks that amount to incitement to violence and so on, and we don't see protection. And in fact, we see that the individuals who are attacked in this way often don't even seek protection from the courts because they don't really trust the system to operate effectively. There's a case we did many years ago when Ahmadi publications were prescribed through government orders, I think back in the late 90s, perhaps early 2000s. And in that case, we did go to court on behalf of the Ahmadi community in public, human rights groups went in the public interest petition, and they got orders to have the books released and the publications available. But, you know, we're all concerned about whether we could actually eventually get a judgment actually upholding that at this time when there's been so much regression in terms of you know, what the public discourse is and the kind of co-optation, as I said, and the patronage of religious groups. So I think the reality is that, yes, either secular voices or non-religious voices don't have that protection and rather face the opposite situation, that they're going to be barracked and pilloried and, you know, accused of hurt sentiment.
Yeah, thanks. I think the question was actually asking about people who self-identify as non-religious. So that was, but you've addressed that, Sara. Did anyone else want to take it on, or we can move to the next question? Amber, do you want to start with the next question?
Yes, sure. So it's a really important question, something that I thought about myself a great deal when I was living in Pakistan, which was a while ago now. I think the interesting, for me, there's an interesting psychological aspect of this question, and that stems from the need to, you know, something that I touched upon in my opening remarks as well, that this need to define yourself or this need to establish your identity. And, you know, it's one thing to say, oh, we're Muslims. And then when you peel the layers a little bit, you say, well, what kind of Muslims? Because to borrow from Sara, you know, it's not a monolith. There's as many shades of being a Muslim as there are probably Muslims. So which sector you're going to adhere to, which, you know, which sort of imam will you pray behind? I'm sorry, I don't personally know as many by sort of categories of being Muslim as well. But I think that this, what we see now in Pakistan, this sort of tension between Muslim and Muslim is because each one is vying to hold that ultimate prized spot of, you know, we are the correct type of Muslims. Because where does this definition end? You know, once you start on this process of exclusion, you know, it starts at the outer limit where you say the first distinction is between Muslim and non-Muslim, but then you have to keep, when you sort of look into it more deeply, I think this is the problem we had with the Constitution, what I call the Islamization project as well, that, you know, which kind of Islam were we going to adhere to? You know, there's so many different ones, and each different groups of Maulvis were trying to assert their particular brand of Islam on it. So I think that's where this tension stems from. And so it might be Muslim against Muslim, but it's actually between, the need is to actually assert a certain type of identity. The second part of your question, which is why is the reference to the colonial construct still relevant? I would say it's relevant because that started the process of categorization and self-definition. Because again, I'm not a historian, but legally speaking, we did not have these categories in law. These were categories, these were social categories. They were there to, for us, for Muslims and Hindus and other religions. I mean, there were multiple religions coexisting in South Asia or British India at the time, but they were not legally identified as different interest groups who had to relate with each other. When the British came in, of course, by introducing different offenses of blasphemy and seemingly as shields to protect one religious group from, another, and from one religious group hurting the sentiments of the other. What they also did was start creating a legal category of identity, and it is that category that, in fact, we are still in the process of defining and refining, and we can't seem to break out of it. So even though we have 70 plus years of majority Muslim rule in Pakistan, it's what I refer to as that inherent insecurity that comes from that process of self-definition, and we are still in that process. We haven't emerged from it. I don't know if we will emerge from it, to be fair, but I could go on this a little bit longer. I don't want to take up other people's time.
Thanks. We'll come back to you for sure. We have questions raining absolutely at the moment, but could I just mention here, and I say this completely from an academic perspective, but an academic perspective that I have lived through, which is that Sara mentioned this very important point about Ahmadis. Now, whether you look at Ahmadis or Nizaris or Bohras or Ismailis or whatever, and the point that, Amber, you are raising about categorization. I mean, look, if you look at the Ismailis or the Ahmadis who are categorized, if we must use that word, as Muslims, in one part of South Asia, but are not identified as Muslims in another part of South Asia, these also then engender their own kinds of problems of engagement, which has very serious implications for the wider good. One of which is the point I think that both of you are making, is this whole idea of seeing Muslims as an individual Muslims, followers of the faith, as a completely homogeneous category, and the danger that has unleashed in the non-Muslim world in terms of perception. It's very seriously dangerous. And earlier in my life, when I was teaching undergraduates in London, in a cosmopolitan city like London, it was quite a challenge to explain to them that it is not a homogeneous block. When you say Sharia, you're not referring to a big fat green colored book, but you are referring to an extremely complicated system of practices and rules and laws and so on and so forth. But there you go. Sara, I think you should respond to the question. Would you like me to read the question again to you, or?
If you would read the question again, yeah.
Okay, so I'll read the question again, a bit quickly this time. Blasphemy is used as a tool beyond affect. It is deployed for hegemonic control and erasing minorities or forced conversion, but most of all, it is used most in intra-Muslim attacks. So what is Islam being threatened by if everyone who's involved are Muslims claiming injury? What is the value of analysis of the colonial aspect of a law when it is completely co-opted and used for the benefit of Muslims by Muslims against Muslims?
Yes, well, I think one of the benefits of the analysis is to point out the sheer hypocrisy of post-colonial states hanging on to these colonial laws. So I think it's worth it for that alone. But I think, well, I think that point about Muslims using it against Muslims, but equally, I mean, Hindus using it against Hindus in the Indian context. I mean, the current regime in India is encouraging the use of this by its own supporters and others against progressive people of all denominations as well. So I think it's not a Muslim problem alone, unfortunately. Would that it were, but it's and the fact that the colonial law is framed not in terms of, it's not like blasphemy, that it's not framed in relation to just Christianity. It does talk about religious sentiment, and as the authors have pointed out, and we've also spoken about it now, that it came in historically as a minority protection device, but very soon, in terms of the politics of all of these countries, was very quickly seized upon as a very kind of helpful tool for those who wanted to shut down any kind of dissent, including dissent about religious views and perspectives and so on. So in Bangladesh, for example, we've seen it being deployed in the past in the penal code, the 295A version, but now also in its in its sort of modern versions in the Information Communication Technology Act and the Digital Security Act, which deal with online hurt to religious sentiment. You've seen it being used against baul singers, you know, wandering singers of Sufi songs, essentially, who come from a very different tradition of Islam. One of the people who spent a huge amount of time in prison, only been released very recently, was Shuriat Bayati, again a baul singer. It's been used. One of the cases we did many decades ago in the 90s was Taslima Nasreen, the writer, you know, who's not nominally a Hindu or a Christian. She may or may not be a believer, but she's called Taslima Nasreen. She comes from a Muslim family. And of course, it was deployed against her. So, and we've seen it, in fact, we have seen it mainly being used exactly by certain Muslim groups in a very political fashion against others. And the big question, I guess, it throws up is, why does a state which professes to be a secular state, I mean, in Bangladesh, our constitution still says that secularism is one of the, you know, 4 principles of state policy. But of course, we have this peculiar contradictory situation that Islam is also now our state religion, and a position that is retained by our current ruling party. So in that context, I think what we can see is, you know, we don't have a kind of robust secularism at all. And we have instead this alignment with trying to appease. I don't know if it's about, I don't think it's about any kind of piety or anything else, but it's about trying to appease and keep in the fold certain kinds of religious groups. And this kind of populist stuff, you know, throwing a few secularists to the wolves, throwing bloggers to the wolves, having people in prison for what they say is part of, you know, fanning those flames and keeping those people on side. So in fact, this very much this process that's written about in the book about how this group called the Hifazat-e-Islami first were facing, you know, arrest and, you know, violent attacks on them by the police and security forces and so on, but then became the best friends of the government and have also won all kinds of concessions in terms of, you know, what kinds of in terms of changes in the education curriculum. The Qawmi madrasas, which are considered to be some of the most regressive kind of forces in society, are now recognized by the state in terms of graduates of Qawmi madrasas can enter the civil service. So I think, you know, this issue about religious offense is tied to all of these other, the use of the religious offense laws and the use by Muslims against Muslims. It's not necessarily just extremist Muslims getting worked up with other Muslims. They're being deployed in a particular way. And many of these cases, I think it's also interesting to see, many of these are third-party cases. So the person is often not even being offended. The person who's going off and filing the case is saying, I am being offended on behalf of X, Y, or Z. And quite often they're offended on behalf of some political party. It's not just their own personal piety or, you know, religiosity that they're speaking about. So I think, again, that political context needs to be brought in with understanding whether it's Muslim against Muslim or Hindu against Hindu. It's in the context of the use of politics and fundamentalist politics and the use of politics by non-fundamentalist, secular, authoritarian groups, and that combination which is seeing this play out.
Thank you, Sara. Paul, I'm just going to come to you. I know you want to say something. That's Paul Rollier. But Sara, I'm going to forget this, but we must communicate separately over this. I watched the interview of the Center for Inquiry Richard Dawkins Foundation on Saturday with Javed Akhtar. And he makes this very interesting point that it doesn't matter, because Richard Dawkins asked Javed Akhtar, what do you mean when you say you're a Muslim atheist? And Javed Akhtar said that, well, I'm an atheist, but I say I'm a Muslim atheist because the world looks at me as Muslim. It identifies me as Muslim because I have this name. So I could just say atheist and stop at that, but I make it a point to say I am this and that. I'm saying this in the context of what you just said about Taslima Nasreen, which is a very important point. I'm going to come to Paul Rollier, but could I just read out a question for our Myanmar people, which is Iselin and Paul Fuller. And it's an important question. If any of you want to, may have something to say as well. Again, with the request, please could you keep your answers brief. Were there questions of offense or blasphemy which constituted part of the attacks on the Rohingyas? So was this ever used in the context of the Rohingyas by the Buddhists in Myanmar? We will come to you later. Paul Rollier, you wanted to speak.
Thank you, Nilanjan. And I just want to come back to the second question that was asked about intra-Muslim tensions. And I think Amber did a great job at answering this question already, but I just want to add a few thoughts to this. And it's true that most of people who are accused under 295 ABC and other blasphemy laws in Pakistan are Muslims, but most of them are in fact Shia Muslims, who are a minority within the Muslim community. What I find really interesting about this is the extension that is taking place, which is to say that every religious community or every even Muslim group seems to be adopting the same rhetoric. And in my ethnographic work with Christians, for instance, I noticed that within the Christian community too, this rhetoric of hurt feelings and of the demand to have special laws designed to protect the Bible and Jesus, for instance, is something happening now. And I noticed this on different levels. So the Supreme Court of Pakistan in 2017, when it criticized the TLP for this sit-in that they did in Islamabad, argued that this organization had used a filthy, abusive language to talk about religion. So they were accusing those who were denouncing blasphemy of using an abusive language. In the case of India too, we see that some progressive groups who are themselves accused of being blasphemous use the rhetoric of hurt, secular feelings in order to make their cases heard. And I think there's something very mimetic going on between different religious groups about this, which partly accounts for the expansion that we see of this language of hurt religious feelings. So I think it's important to keep that in mind. And the last point is about the fact that there is no single Muslim community. And I think our book goes to great length to show how the rivalry, for instance, between Deobandis and Barelvis in Pakistan goes a long way towards explaining why blasphemy gained so much preeminence over the last 10 years in the country. So we do talk about this quite a bit. Yeah.
Great. Iselin and Paul Fuller, did you want to take the question on Myanmar, please, and the Rohingyas?
Right, yes, thanks a lot for that very important question. To my knowledge, offense of religion against the Rohingya or from the Rohingya versus the state has not been an issue at any point at all. Basically, what's going on with the Rohingya crisis is that the Myanmar state does not recognize Rohingya as an ethnonym. So it's a question of the state codification of ethnic and religious identities inside of Myanmar. And the state recognizes 135. The number has changed through history, but it's dependent on colonial understandings and colonial sociology of colonial subjects. Now, the Rohingya was never accepted into that list, and that's the reason for why the Myanmar state claims them to be illegal immigrants from Bangladesh. As far as I know, questions of religious offense has not been. I mean, if power dynamics in contemporary Myanmar would have been otherwise, then one could have thought that the British intention of religious offence legislation as a minority protection device, as Sara Hossain mentioned here, then it could have been used for the protection of the Rohingya against this massive anti-Muslim hate speech in the fall of 2017. But the power dynamics does not really allow for minorities to use the legal system in Myanmar to secure their interests. Paul, would you like to add something to that?
Yeah, I think you're perfectly right, Iselin. There's no concept of blasphemy with reference to the Rohingya. I would just add, though, that there's a lot in the Buddhist monastic community, particularly to do with these groups that we've mentioned, where there is kind of outrage against these minorities, discrimination and Islamophobia. And there's also sermons made, so this does not, I'm agreeing that there's no idea of blasphemy, but some very revered Buddhist monks have made sermons in which they support the genocide against the Rohingya. And they do so. One notable example, I won't name names in a discussion, a public discussion of this nature, but they have used Buddhist texts like the Sri Lankan Mahavamsa in order to support the genocide against the Rohingya. So I'm stopping because everyone's disappeared from my screen. I'm not sure what's going on.
No, that's fine. We can still hear you.
Oh, you can still hear me. Yeah, so sorry, everyone's disappeared. So I was a bit worried if I was speaking into the kind of nothingness. So there is kind of notable examples of leaders of very revered monks in Myanmar giving sermons to groups of army officers in which they use a text like the Sri Lankan Mahavamsa to suggest that the Rohingya are not Buddhists, therefore the genocide is justified. But there's nothing to do with, I would follow that up just to emphasize it's nothing to do with blasphemy. So I'll finish there. Sorry, I can't see anyone, so I'm a bit confused.
No, thank you, Paul. We could hear you clearly. I think you may have a slight problem with your connectivity, so you may want to switch off your video, in which case either we might appear or you could at least hear us. Okay, no, I have another question, which I'm going to read out. This is long, and I'm quickly trying to figure out what is the quickest way to do this. So the question is directed towards the two editors and towards Iselin, but the content of the question actually is as much for Paul Fuller, for Sara, as well as for Umber. So I'm going to read this out. I'm going to read it out slightly quickly because it's long, but if you want, I can then read it out again in brief. I was interested in what Paul Rollier described as repertoires of outrage. This made me think of John Bowen's description of repertoires of justification in Indonesian customary law as taking measure of some kind of public consensus that sits somewhat outside of legal precedents. So it's a bit about customary law and the sorts of things that we were actually mentioning earlier in the context of Myanmar. I thought the notion resonated with the discussions because a repertoire requires renewal, change, and most importantly, people to keep it in play. I was wondering if you could say, you as in, the question is addressed to the anthropologists, could say something about how you engaged with feelings of consensus and dissensus over what constitutes religious offense on a more day-to-day basis when you are in the field. So the question is addressed towards the anthropologists, but the reason I wanted to bring the commentators in is because it actually ties up a lot also with what all of you have been commenting about, is the whole question of a wider justification, a wider belief, and that. Who wants to start? Kathinka, you've been quiet for a while.
I have. I was just thinking of how to respond to that question. Maybe the best response that I can give as a field-working anthropologist deals with actually another case that I have not discussed in this particular volume, which is how censorship controversies that people hears about, learns about through the media serves as models for action. So there was this particular case in the neighborhood that I work in northern India, an urban neighborhood in which you know, one of these deity tiles that people paste outside their houses, it was ruined because the people living in the house had converted to Christianity and so on and so forth. And the question is, what should the neighbors think about this? And of course, many of them thought that they should react. Others thought, well, if so, what do we do? You know, and so there was a long discussion about how to deal with that particular incident. But how how the sort of presence, continuous presence of these cases in society, in the media, and how they circulate also serves as models for action. People feeling that they should come out and defend their religion. And it's a sort of impulse to do that. If not, you feel as if you're a bad Hindu or a bad whatever, you know. And I think that's an important phenomenon that I see sort of emerging in my fieldwork, this impulse to act, and also the indeterminacy. Okay, if we should act, then how should we act, and what will happen? Who should we approach? What should we do? And people saying, well, is it really worth the trouble, or can't we just, you know, be good neighbors and forget about it and move on? So that, you know, those differences of opinion, they are there all the time, and they determine to a large extent whether a case becomes a case, or whether it just becomes a local commotion that dies down and do not hit the records for historians and maybe even not anthropologists. So yeah, they work. They have, I mean, the cases have a kind of a feedback effect, which I think we need to, or a recursive effect, which we need to take into consideration as well.
Paul, the question was originally directed towards you, so.
Yes. I'll answer first the second bit of the question about fieldwork, because I think it's an interesting one. Trying to grasp for us, I think, blasphemy or religious offense in the field is inevitably very difficult for many reasons. The first is that blasphemy in itself is an accusation as much as a description of something. So oftentimes you find that there's nothing behind, there's no blasphemous content lying behind an accusation. So it's really trying to understand how that accusation moves around between different actors. But how do you do fieldwork around this? That was one of my dilemmas anyway. And one way of doing that was to pay attention to I guess, the embodied dispositions and habitus and ways of handling sacred matter and sacred words. So how do you talk using sacred words in the streets? How do you handle a Quran and things like this? So that's what led me to materiality as a roundabout way, really, to try to grasp what these enduring dispositions were about. And to answer very quickly the first part of the question about the repertoires, I think in Pakistan, at least, there starts to be a number of works that look at this. And one of the chapters by Shafleshner is very interesting in this, to really try to trace the history of this sensibility and how it's been reactivated at different intervals. Amélie Blom as well, a political scientist from France, has written about the anti-Danish cartoon protests in Lahore and how these reactivate the memory of previous protests each time. So I think these are, you know, a very interesting direction for further research.
Thank you. Iselin, did you want to?
I was just listening to the very wise comments of the editors here. Just adding to this last point that Paul made about the sensibilities and the reactivating of history. I mean, there is a historical reservoir here that can be tapped into and played by certain actors as well. And I think we have a recent case in Myanmar now where there was this very popular K-pop group that went to Korea to dance. And what they didn't know was that someone on the show actually had put visuals of the most holy sacred space in Myanmar, the Shwedagon Pagoda in Yangon, illuminating the floor, but the dancers could not see that. So they didn't know actually during the performance that they were actually trampling on the most sacred place of Myanmar. And then afterwards complaints were made. And of course, to the Burmese Buddhist population, this rings a whole sets of historical bells. This was the place in which the British soldiers clamped in with their footwear on and claiming that it was not their sacred space. So it was declared official space and not sacred space. So therefore they did not have to remove the shoes. And the question of removal of shoes is one of the sort of the beginnings of the actual Burmese resistance to British colonial rule. It's sort of the beginning of the end of British colonialism in Burma. So this offense, trampling on the Shwedagon, rings, you know, a long history of resistance to foreign forces that do not really respect local culture.
Sara?
Yeah, I mean, I think that on both sides, actually, the repetition of these, and you say the invoking these images and these experiences and histories, well, it works in two ways. As far as the groups that are bringing, that are claiming to have, you know, hurt sensibilities and so on, obviously doing that over and over again makes that they're able to kind of consolidate their forces and build their alliances around that. And also able to sort of shift the discussion. In part, as it's written about in the book, it's used partly as a critique of the kind of political opposition and so on. But it's also there, I think, the way at least in which the state sort of patronizes that is to deflect attention from other more trenchant political critiques, to kind of take all the oxygen away into this religious belief, hurt sentiment debate, rather than the discussions around, you know, the democratic deficit, authoritarianism, and so on. And as far as the victims of all of this are concerned, those who are subjected to these kinds of cases, I think Paul, editor Paul, rather than Dr. Fuller, did mention that, you know, if you look into the cases, actually there may not be anything to do with any kind of hurt to religious sentiment. The whole thing is a puff of smoke, actually. But that puff of smoke works very effectively. No one looks into it. There's no scrutiny of what the actual allegation is. It's in, and particularly now in these new offenses where there are no checks and no safeguards. By the time you discover that there's actually nothing going on there, that it's an utterly absurd allegation, no one could even be remotely hurt by what was said, someone has already spent months and months in prison. So I think the effect it has on those who face these allegations, as well as many of those who are not directly implicated in cases, but, you know, may feel that many of the comments made are rational comments. They're comments that come in terms of rational, rational debate or critique of some kind of perhaps religious practice, or not even that quite often. They feel silenced and they feel much less able to go out and take part in not only street demos and all of that, but to take part in rational discourse. So what it's really done, I mean, what we've seen post-2013, particularly with the attacks on bloggers and then the sort of violent, brutal, I mean, beyond being hurt by anyone's I mean, that's the other point I think people keep making, that on the one hand, you have people going on and on about how their sentiments are hurt. On the other side, you have people being murdered, you know, with machetes, which is a lot worse than having your sentiment hurt. But even then, they're sometimes being blamed for hurting sentiment, almost as if they asked for these incidents to happen. So I think that context, so we see that kind of extreme violence, which is, you know, with a level of impunity. Of course, there are investigations on, there are cases filed, but we haven't seen, you know, that many people being brought to account for those. And we haven't seen these broader groups that enable an environment within which those kinds of threats can be made. We haven't seen them being brought to account at all. So you see this complete imbalance, and it means one group feels frightened, terrified, I would say, particularly with, you know, Facebook mobs and so on going after them, and the lack of any kind of, you know, we're also being cautious about what we're saying because we live in that reality. So I think it reinforces that sense of fear on the one hand, and on the other hand, it emboldens those who are pushing further and further with irrational critiques to try and shut down, you know, conversation and debate.
Amber?
Yes, I think that, so I can speak a little bit from my personal observations on this issue in Pakistan. I think initially, you know, the sense of this feeling that, you know, we're not, you know, we might have a country to practice a religion, but there is need to do more to make it fully Islamic. I mean, this was what I was talking about as well in the opening. So I think there's what I call the trauma of the partition, you know, that the reason we had to give up or the reason we had to form an independent country is because we were not free to practice a religion. And I think initially that sort of sense was curated quite carefully by the state itself. So there was, you know, every time there was a threat from the outside, or especially from India, if it was real or perceived, it was made into a religious threat. So that sense of, you know, that feeling of insecurity, which I referred to earlier, was constantly reinforced. carefully by the state. What I witnessed, and this is the personal observation that I want to talk about, what I witnessed back when we had the Lal Masjid crisis, I think it was it 2010? I can't even remember the year now, but I was living in Islamabad. There, if Paul remembers. I was living in Islamabad at the time. And that crisis was really interesting because it brought the state and religion into immediate sort of confrontation with each other. And the state of a military leader, which in Pakistan is the other holy cow, right? It's either religion or the military. You don't speak against either. But when they were in confrontation with each other, and there was a sense that the army had acted against, religious leaders or imams or Maulvis or madrasas, the sentiment or the sympathy was entirely with the madrasa. There was really no sympathy or understanding for the state. And I think that is what I see as sort of a shift. It may well have been the point where it shifted. I'm not sure, because again, I'm a bit late to admit in the day that this is not my area of expertise, and I'm mostly looking at it as a lawyer who has practiced in Pakistan for a very long time. But I think that may well have been the point where the narrative shifted from being curated by the state, and it slipped out of their hands and became people-led. And I think we also see that the blasphemy accusations really, people took it much more in their own hands. So then the need to protect religion became, whilst it was, like I keep saying again and again, it was something that was sort of carefully orchestrated and curated for a very long time, it has spiraled out of control to some extent. And now everybody feels, and I think there's a greater distrust of the state. There's a greater distrust of the judiciary. And what I see happening is that they're all going on the back foot. So I think that is a big factor that has led to the increased sort of, and I mean, it's not just the violence. We talk about the violence, which is of course very, very sort of in your face and it's unmissable. But just yesterday, I was, when President Macron made that statement, which was some anti-Islamic statement, I don't remember the exact words. And then I saw on Facebook, friends of mine, people I know, putting up posts, sort of statuses saying, "Oh, I'm a lover of Prophet Muhammad." So there's this constant sense of threat, but it's now no longer curated by anyone. I think it's very much an individual sort of feeling that people have imbibed. And I think that has become the feedback loop. Which reinforces itself, it sort of disseminates through social media as well.
Paul Fuller, did you want to say anything about the question of repertoires of justification?
Yeah, my computer was still having a bit of a meltdown during that question, so I was kind of playing a game of catch up there, trying to work out what the responses were to which question. So I don't really have anything to add at this point, Nilanjan.
Okay. Thanks. So I think we have less than 15 minutes, and I am going to give all of you the chance to make some closing remarks. But I think a lot of us, and definitely Sara, would like you to say a bit more, and then Amber, but all the others. Before that, Amber, Lal Masjid was 2007. Well, if we go by Wikipedia. Is the very important point, Sara, you made, which was about the institutions of legality, the legal framework within which we function, and their effectiveness, their potency, and etc., in being able to uphold the rule of law, or their inability to uphold the rule of law, alongside the whole question, again, something that you yourself mentioned, about how people, by embedding and re-embedding colonial laws in post-colonial, post-constitutional contexts, people are, these become avenues for people to use to register offense. The reason why this question is important is because, and I've been listening to every word each of you have been saying, all of you together are also a unique group of people who function both in the European context as well as in South Asian context, either because of your research or because, as in the case of Sara, she works in both places, and etc. And while we always go by the argument that, oh, you know, the rule of law is upheld through institutions in relative terms more strongly in European and Western European contexts, it is not as, and you know, we don't hear about religious offense and blasphemy in those forms over here. There is a simmering and a palpable threat of what we have come to call populist feelings in various parts of the world. So I'd be very keen to hear from all of you very briefly what you think about the effectiveness and ineffectiveness of institutions in being able to uphold law in various contexts. Unfortunately, we've lost Utsav, but Sara did make the very important point about what we are witnessing in India at the moment. But you know, comments welcome. Sara, did you want to start?
I think, yeah. Well, I think we need to look not only at the colonial law, but it's, as I said, its successors, its progeny, in terms of the new provisions that we've created in some of our countries, particularly the provisions that relate to online speech. In Bangladesh and abroad, there are Bangladeshis speaking about the problems with our Digital Security Act, which includes this thing about online religious hurt to religious sentiment, but also actually, I think, looks at how that whole notion of offense in this context has migrated to talking about hurting images, hurting the image of the nation. In our context, in the Digital Security Act, we also have an offense of speaking, of making propaganda against our liberation war, or speaking about the father of the nation. And those are kinds of almost blasphemy offenses, but secular blasphemy offenses, dealing with ineffable, you know, amorphous issues about history. And I think so what they do, what I think is very sinister about this is that at least I think my perspective on the religious sentiment laws is that they stand in the way of ensuring they don't really work as minority protection devices in the context of how our legal systems operate and the kind of broader kind of political frameworks. They do act to suppress democratic aspirations and practices. And we see that they have been a kind of building block on which, and many of the kind of practices of abuse that have related to the use of religious offense laws have been used to then bolster up newer laws, you know, which are even more problematic, and to restrict that space even further. So the kinds of, you know, cases we're seeing around use of sedition laws, for example, I mean, again, it's extraordinary, isn't it, that we have post-colonial states which do not tire of telling us about their proud, you know, nationalism and all of that, and flying our flags all across our region. We never tire of that. And it takes 2 minutes to denounce everybody as being anti-national and all of that. But then why is it we're using sedition laws from British times? Why are we using ideas of religious offense from British times and making them worse? So I think that debate around, you know, that knowledge of the fact that these come from these colonial origins, and they're even worse than what Lord Macaulay and his, you know, successors thought up, is something that needs to be reiterated over and over again, that these are not connected to our, you know, proud histories of nationalism. They're not connected to any notion around independence or sovereignty, which should be about standing on equality and talking about inclusion and talking about diversity. The rhetoric of some of that is there, but it doesn't match with the reality, which is very much a reality about sort of repression and silencing.
Okay. Amber, did you want to speak?
Yes, thanks, Nilanjan. So I thought I would address this question slightly differently. And if I understood you correctly, you were asking how the rule of law is being maintained, you know, through how the institutions are responding to the rule of law question and religious sentiment at the same time. So I think Pakistan had an interesting innovation back in 1985. This was Zia era, where we amended the constitution to create a federal Shariat court. Now that was, you know, people have been railing against it. It's a horrible thing that Zia did. But in fact, I thought it was quite clever, because what he did was create a separate forum for religious issues, and the federal Shariat court was going to have you know, reasonably exclusive jurisdiction, but he retained the secular legal system almost intact. and the secular legal system was free to decide, almost every single issue. So we don't have Sharia law in Pakistan, as I'm sure everybody on this panel knows. And the reason we don't have Sharia law, except in very specific areas, is because the secular legal system was maintained. And the idea was somehow that we would be able to, going forward, be able to maintain some sort of a bifurcation between secular legal issues and religious legal issues, and somehow end up preserving rule of law by doing that. So initially, I think it started off reasonably well. So we had a very important religious case of religious overtones, not blasphemy, but this was the riba case, which was against the charging of interest. And the Supreme Court said, we're not going to decide on this. This is really a religious question. It should be sent to the Federal Shariat Court, and the Federal Shariat Court should the Federal Shariat Court should do a comparative analysis and find out how riba is dealt with throughout the Muslim world. What we've seen over time, though, is that the secular legal system is becoming more Islamized. So this is something we're talking about 2000, when the riba judgment was finally sent over, or the riba case was finally sent over to the Federal Shariat Court. But in more recent times, if you look at, say, the very famous 2014 judgment of the Pakistan Supreme Court by Justice Tasadduq Hussain Jilani, which was for minority rights, and he upholds the right to religion, and he talks about liberal values, but he equally talks about the liberal values being in consonance with Islamic values. So what we are seeing is that Islam is, or the reference to Islam, the reference to various Quranic verses has become mainstream. So for instance, even if you take that, the Asia Bibi case, the secular judges in the secular legal system sitting in the Supreme Court actually take it upon themselves to interpret Quranic verses. Just, I think 2 days ago, the Supreme Court passed an order in the reference filed against Justice Qazi Faiz Isa. And again, they start with invoking the Quran and then go forward. So I think what is happening is, and I think this has important implications for blasphemy as well, but what I see happening is that the Federal Shariat Court has in fact become quite irrelevant in the scheme of things, and the responsibility of interpreting law in accordance with Islam has been taken over by the secular courts themselves. So the secular system has become Islamized, which Zia, with all the bad press that he gets, probably deservedly. I was not really, fully sort of cognizant in those times, but I think he still had created a bifurcation that may well have been capable of keeping some rationality there. But I think it's the popular momentum, the populist sort of surge, the need to assert that Islamic identity that's taken over, and that is now being reflected back by the institutions. What does that mean for rule of law? I think that's a really sort of a tough question. The good news to my mind is that Pakistan is not the only country grappling with that question. So I think some of us who are interested in comparative studies of whatever kind can look across a very sort of unusual example, but an important example is Israel. Israel is grappling with that question all the time. What does it mean to be a Jewish citizen? Is it going to be decided again in accordance with liberal democratic values that Israel really prides itself on? Or is it going to be a question of Jewish law? Interestingly, Israel did decide it was a question of Jewish law, but it was a majority of 6-5 judgment. So you could see it could have either gone one way or the other. But I think going forward, these questions will become more and more important, and we will see the question of rule of law being increasingly interpreted on the touchstone of Islamic values, and keeping in mind the popular sentiment that you created a country for Islam, you sort of made us sort of do many things along the way because you said, and by you I mean the state, not you, Nilanjan, that this would be you're doing it for Islam, or we're making sacrifices, but then give that Islam back to us. So I think that's the mainstreaming that I see happening.
Thank you, Amber. We are terribly short of time, actually. It is exactly 5 o'clock. So could I withdraw my offer to make closing remarks? And but I'm afraid I can see Kathinka's surprised expression. So could I just request all of you to take a minute and make closing remarks, but we should wrap up as soon as possible. I hate to do this, but it's just the way things are. It has been a fascinating discussion, but shall we start with you, Kathinka?
Yes, please. I promise to be very short. Okay, the book that we have edited is not normative research, so we don't really come with any suggestions as to what can be done. We diagnose some problems that we think are general. Also, as foreign scholars, there's a limit as to how much we want to suggest these old civilizations to do. But I want to point to what I think is important, which is not to just seek solutions within the institutions and within the legal systems themselves. Yes, that is crucial, and yes, that needs to be protected. But I think it is also a problem that so many cases end up in court and take like forever before cases are solved and persons acquitted. So the more cases that can, but the more blasphemy accusations that can be solved outside of court by other means, I think the better it would be. It could be in terms of public debates, it could be in terms of humor and jokes, it could be in terms of seeking apologies. We need to find good models for solving blasphemy accusations, or dissolving them rather, outside the legal systems without the use of violence.
Great, thank you very much. Paul Rollier?
Yes. Well, I would just like to use this time to thank you all again for taking the time to read our book or part of the book. That's very kind, and I wish we had more time to talk about it. I have a lot to say about the last question, the rule of law, but I won't get into it. But I think as social scientists, it is a very important task for us to simply understand first what is happening around this, to try to gain an anemic understanding of the situation before making recommendation, which is really not our role. And I think there's still a lot to do in simply trying to understand people's perspective around these issues.
Iselin?
Yes, I'd just like to second the editors here in thanking everyone for making great contributions, and to you, Nilanjan, for organizing all of this. And just a short reminder, as a religious studies scholar, I think we need to remember that rather than religion creeping into the courts necessarily, trials serve as a religion-making instrument or technology that produce certain forms of religion, and that goes across. I think that some of the comments made on intra-Muslim rivalries could very well go for intra-Buddhist rivalries, etc., etc., etc. So thank you all.
No, thank you. In fact, there was a comment on Facebook that in Bangladesh, it has also been intra-Christian rivalries where Christians have used it against Christians. So that's it. Paul Fuller. Maybe Paul can't hear us. Paul Fuller, can you hear me? Did you want to say anything just as a closing remark?
Just as a closing remark, thank everyone for their time and very interesting discussion. Just to point out, in the Buddhist context, we've often got to avoid the universalistic idea of Buddhism and realize that there's an idea of a local form of Buddhism in which politics, culture, society, and often violence and blasphemy, that's where we're going to find the Buddhist discussion and conversation about some of these issues. But I thank everyone. It's been lovely meeting everyone.
Thank you. Sara?
I think that we should talk about the universalism of human rights here, and the fact that whether we're foreigners or we're from different societies or different disciplines, we ought to be talking about protection of rights and rights to equality and freedom of expression and freedom of association, and looking at how these religious offense laws are an incursion on those would be the perspective I'd suggest people take. There's a lot of stuff out there, whether you're activists or not, about what abuses are going on through the use of these laws, and I'd urge everyone to look at that work and try and add your voice to try and change the situation on the ground. This is not just about academia, it's about people's lives and things that are happening every day.
Thank you, Sara. Yes, that's a very important point. Amber, you have the last word.
Yes, well, very grateful to everyone for an excellent discussion. I was probably an outlier because I'm not an expert on blasphemy, but I really enjoyed this. I just want to say, from my perspective, it's really important not to see blasphemy as a religious or even a legal problem, but as a political problem and how power is shared between different groups in society. And I really do think it is about who is wielding the stick, and it's being used in that way. I also just wanted very quickly to respond to something Sara had said, when she started her speech. I have responded to her privately, but just for the record, when I mentioned the great secular leader Bhutto, that was very much in inverted commas. I think the point I was trying to make was that everybody has fallen prey to the rallying cry for religion, even those who proclaim themselves to be the so-called secular leaders of Pakistan. So Bhutto and Benazir both fall in that list. And when we take stock of Pakistani politics, we often sort of see them as black or white, and that should not be the case. So that's just to put on record that that we do try to see this as a power struggle rather than defining people as black and white.
Thank you very much. Thank you, everyone. This has been very, very enjoyable. A recording of this will be available tomorrow on our website. And before I thank each of you individually, as also our very loyal audience who have been with us, I do think it is absolutely fair that I say on behalf of everyone that the point that Sara made, that this is certainly, this is an issue, this is a topic, this is certainly not about academics alone or for courtrooms and for legal cases. It's actually happening to real people in real time. And the most potent way perhaps is for all of us to speak up in our own ways, in ways that we can, to bring a perspective on what is not only very dangerous, but is in several instances, unfortunately, also fatal for some of the people who are involved. But could I please thank the editors of the volume for bringing this book about, which has led to this discussion. I want to thank Paul Rollier and Kathinka Froystad. Please also thank Arild and Iselin Frydenlund, who participated because of her chapter on Myanmar, Paul Fuller, Sara Hossain, Darr, and unfortunately Utsav Bains, whom we couldn't have, but I'm sure he would have contributed very well to this conversation. Thank you, everyone, and goodbye from London.